Today, Republican Senator Josh Hawley and Democratic Senator Richard Blumenthal introduced a bill, bipartisan, that would restrict AI companies from using copyrighted material to train their models. It's called the AI Accountability and Personal Data Protection Act, and it would allow people to sue those companies for using their data without consent, creating a cause of action. Of course, how do you police this sort of thing? These kinds of conversations around enforcement continue, but there have been a series of lawsuits over training materials and beyond for these large language models. Now, this comes just weeks after the Senate voted down a rule in the Tax Cuts and Spending Plan that would have banned state-level regulation of artificial intelligence for 10 years. States can, in fact, regulate, but it's been difficult to get some of that passed, including in California, and we'll talk about that in a moment. This all comes just after the House of Representatives held Crypto Week, when it considered a series of bills around cryptocurrency, seen as a dress rehearsal for regulation for artificial intelligence. All this illustrates the current tension between Silicon Valley and Washington, D.C. to regulate or not to regulate. Joining me now in studio to discuss all this as an expert in this field and beyond it is Dr. Gregory McNeil, professor of law and public policy, Pepperdine University, expert on technology law. Dr. McNeil, welcome back to the show. So much to talk about.
Thanks so much for having me back.
You know, we think about this in terms of big tech, the U.S. government, and China's over here too, right? And it's innovation or regulation. And big tech is saying, if you don't let us innovate, China's going to do it first. But by the way, do want to sell some chips and stuff to China. And the United States government is trying to figure out which side to come down on. How do you see it? Break it down for us.
Yeah, it's interesting that none of this really breaks down on the traditional left-right divides that many of us, well, Gen Xers like me, had certain ways of looking at this.
Right.
One side's on the side of business, the other side's on the side of, you know, the small guy or whatever. And this one, just take Josh Hawley, for example, the legislation you mentioned that he introduced, he's there fighting against big business on behalf of the individual creator, the small guy, who he says is getting beat up. So I think one of the biggest challenges here is trying to keep track of the volume of legislation and litigation. And the bill that was struck down, the moratorium, is going to make this even more challenging for us. Basically, the moratorium said, let's just pump the brakes on new legislation and see what happens. And that's now off the table. So we'll see California spin back up in the legislative session. We'll see New York. It's going to be pretty exciting.
Let's talk about that for a second. We're talking about the big, beautiful bill, and the House had passed this moratorium for 10 years on states to be able to regulate artificial intelligence. Now, the House Republicans put that forward because they said, good. I mean, I'm paraphrasing here, but we have to see that MAGA's been part of the big tech alliance, and so to the extent that they're protecting big tech, and you can correct me if that's totally wrong, but they say, look, let the federal government be the ones to do this, and then we can maybe pump the brakes and not have as much regulation or have more or whatever. But now we have a patchwork opening up, and so you're saying the tension is it's bad because of the patchwork because it's confusing, but then is it also bad because then we don't get as much regulation? Because it's tough to get regulation through California, but it's tough to get regulation through DC too.
Yeah, so I have an opinion on this, right? So I'll give my opinion, and then I'll sort of talk about all of the issues. My opinion on this is that we should pause. Now, I think 10 years is probably too long. The Senate bill did get negotiated down to 5 years. Everybody thought it was in. Then it got pulled back out through all those legislative machinations that nobody really follows. But it was a surprise to the proponents of that piece of legislation that it was pulled out. The reason I think we need to slow down on it is because the technology advances so quickly that oftentimes the stuff that we're writing into legislation, by the time the bill gets signed, is already out of date. And so I think that's why, and by the way, we haven't really seen any actual harms. A lot of the bills are about speculative harms.
Right, and you in particular are concerned about real harms because you're a lawyer, and you know that for standing as a plaintiff, you have to have a real harm to bring it to court. But it's interesting because, as you say, legislation maybe doesn't move so quickly, and the courts can move quickly to some degree, right? This can get to before a judge, then they can rule, and of course there's an appeals process and beyond, but we see that being a potential place. So talk to us about the biggest realms for litigation here. I mean, there's market power monopoly, there's also the training models, there's other aspects to intellectual property. I mean, what do you think are the most expensive when it comes to regulation?
Right, the front-leaning cases right now are on the intellectual property front. Those are your copyright types of cases. Basically, we've had two of them come through. One was against Anthropic, which is one of the leading AI models that's invested in by Amazon.
I want to jump into that too, because Anthropic versus Universal, and it's interesting because it's about song lyrics, which we all love, and Anthropic was training its models on artists that had written for Universal Records to inform Claude to, I guess, write new songs and new lyrics.
Right, and also to learn syntax too, right? And so then the other one was a case against Meta, almost on similar grounds. There's another one pending in the United Kingdom. All of them are basically about, I'll simplify because everybody in the audience is not copyright lawyers. And so basically the idea is you're taking this thing that was my original work and you're now creating new things from it, and I didn't give you permission to do that. So the argument is that's unfair, you're violating my copyright rights, my rights as a right holder. And the argument from the AI companies was, no, we're transforming this. This is like if I watched your show and became inspired to do something similar on my own YouTube channel. Or if it would be great, right? I'll never be able to compete, but it would be great. Or if I read a technical manual about how to perform a certain process, and then I myself did it. So sometimes these companies will take the technical manual that tells you, here's how you write a business plan, right? And instead of typing in word for word, they ingest that info, and then the AI can tell users how to make a business plan. So their side is, this is the same as when, as kids, we used to pull the Encyclopedia Britannica off the shelf, and then we used Google to see what otherwise we would have found in the encyclopedia, and now it's trained on that information, and we get an answer. That's the other side of the equation.
So I mean, the IP is a big, and we saw with the legislation too. What can we train these models on? Can we create a cause of action? And that's a big frontier. There's two other frontiers, are just about regulation in terms of having the AI companies give disclosures for what they're doing. There's a European Union AI Act that SB 1047, the California law, was based on. SB 1047 gets vetoed by Governor Newsom, but maybe something like that is in the offing there in DC. And there's also just the monopoly conversation. So in our, well, we can talk about this forever, and unfortunately we can't. But just if you could talk about those two here and what those frontiers are in a nutshell.
So the one model that we were discussing is sort of about the frontier models, then learning this information, and then what if someone wants to be able to sue and have a private right of action to sue for the information that the model's been trained on, right? That's copyright, but it could also raise issues related to individuals' personal information and personal data that's been collected. So they want to put in a consent regime around that. And then I forgot what your second question was.
I mean, let's talk about monopolies. So the AI stack. I mean, there's chips, so that's like NVIDIA, and then there's the cloud, and that's Amazon with AWS. But Google's got kind of a stake in a lot of these, including the large language model, which OpenAI has, a ChatGPT, and Google has as well. And then it gets to the devices too.
So the big issue there is that this is part of one of the counterintuitive effects of the legislation that was being proposed by Senator Hawley, which is that if you have to go get consent from everyone that you're using their information from, that's really going to empower the larger companies. Someone with smaller resources trying to create something won't necessarily be able to compete along those lines. Then further down the supply chain, we have all kinds of other issues with AI that are burgeoning now, whether it's the energy use issues, the chips issues, exporting the chips to China, which at the beginning of the segment you mentioned this geopolitical competition. We have no answers and tons of issues.
Well, and so in our final moment, I mean, Silicon Valley has always been move fast, break things. I think Zuckerberg said that. And so it's, do you move quickly enough to outflank China? At least that's what big tech is putting out there in terms of the PR. Like, we got to move fast, don't regulate us, otherwise it's going to be China. Is that true? Is it too late to regulate it? Is Pandora, the box open, toothpaste out of the tube?
This is why I think you saw the reversal of the ban on exports of the chips to China. Now the Trump administration has reversed. They realize they're not going to be able to put that genie back in the bottle. So let's do market competition. Let American software and technology companies outcompete the Chinese, because otherwise we're going to be fighting with a hand tied behind our back.
And NVIDIA is like, yes, China.
I hope you have some of that stock.
Oh, God. Honestly, would I be here? I would. The answer is I would, because I love it. And we love having you on. Thanks so much.
Thanks again for having me.
No, amazing conversation. Dr. Gregory McNeil, who understands stuff so well. And obviously, there's a lot of conversations to have from a legal standpoint, but also the just geopolitical standpoint. So we're grateful to have that conversation.
Thanks for watching our YouTube channel. Let Spectrum News be your resource for balanced, in-depth political coverage. And click the subscribe button here. You can also download our app and watch us on TV to learn more about the candidates, where they stand on the issues, and more. We'll see you then.